Hi there. My name is Naomi Metallic. I'm a Mi'kmaq lawyer, and I'm also a law professor at the Schulich School of Law at Dalhousie University in Halifax. I have another video where I give an overview of the First Nations Caring Society decision, the main decision. In this video, as a follow-up to that, I try to explain the individual compensation decision that recently came out from the Canadian Human Rights Tribunal. So let's jump into it. Okay, so as mentioned, there's the earlier 2016 main decision that decided that Canada had discriminated against First Nations children and families. And also at the end of that video, I explained how there had been 7 non-compliance orders issued against Canada by the tribunal since 2016, a lot of them involving Canada not complying with Jordan's principle. But yeah, so we get this decision. It comes from September 2019. It just came out last month. But I'm going to back up that for a sec and talk about the fact that when the tribunal gave its main decision in 2016, the parties had already made submissions at that time in 2000 before the decision. So when they made their final arguments before the tribunal in 2014, they had actually put their positions forward, and Canada was aware of them around their arguments for individual and systemic remedies. That is an important point to make, just because in the appeal and the media that's been around it lately, Canada has said that it needs to, understand the positions, and, it's sort of suggesting that it was kind of taken a little bit by surprise by the tribunal's order. But just to be clear, all of this stuff and the arguments that were being made by the parties in the case were known by 2014. Anyway. Okay, so the tribunal initially didn't want to, or just decided it was going to wait to decide on individual compensation. Let me just stop for a second, explain the concepts of individual and systemic remedies. So when you go to court, whether it's to human rights or some other type of decision, you're looking to have your rights recognized, but you're also looking for what are called remedies, which is the response to the violation of whatever right it is you're bringing before the court. And there's different types of remedies. So here, when we're talking about individual remedies, we're talking about things like compensation to people, individuals, for things like pain and suffering. So that can, sometimes pain and suffering is with respect to what you had to go through if you were in a car accident, for example. But in this case, it's pain and suffering resulting from discrimination. Okay, and then there's also what are called systemic remedies. And so in the context of discrimination complaints, yes, there can be harm to an individual, pain and suffering, embarrassment, these types of things. But there also often is where there's found to be discrimination, and it's the cause of bigger, broader systems that are created by, governments, and I spent a lot of time on that in my last video, how this whole system of child welfare is constructed on reserves. So sometimes if it's a whole system, a tribunal will order what are called systemic remedies, and those are, orders to change policies and to redesign systems. And so here, some of the systemic remedies included, comply with a broad definition of Jordan's principle, reform the First Nations Child and Family Services. So this case is about individual remedies and what First Nations children and families who are affected by Canada's discrimination that I talked about in the last video, what they're entitled to because of that. Okay, so next, September 2019, the Tribunal, so my acronym here, CHRT, that stands for the Tribunal, orders Canada to compensate First Nations children and families who have been unnecessarily apprehended or were denied or delayed receipt of services due to Canada's discriminatory implementation of Jordan's principle. So we're going to see that that's basically two things that First Nations children and families are going to be compensated for. Either they were unnecessarily apprehended, and you'll recall that the earlier finding by the tribunal found that the way that the child welfare system was developed and created, it actually created an incentive to apprehend children before anything else. And also it found that Canada wasn't adhering to Jordan's principle. So so that is the finding. We're gonna delve into that deeper in the rest of this video, but I'll say a couple more things first. As I explained in the last video too, because of the way different First Nations, the history of different First Nations in different parts of Canada, in the Northwest Territories, the federal government does not directly fund child welfare services to First Nations there. Rather, it's the territorial government. And there are issues certainly with those services as well. But they're not funded by the federal government. So with respect to the first finding of unnecessarily apprehended children because of the discrimination in the First Nations Child and Family Services program, youth and their families from the Northwest Territories are not going to be receiving compensation. That said, they're still entitled to Jordan's principle, and so it may be possible that they might be entitled to some compensation in light of being denied Jordan's principle. All right. And the next thing I want to say is, so we get this decision, it comes out early December 2019. We hear earlier this month, October, that Canada has said that it's going to seek judicial review of the decision. So just to explain what judicial review means, it's like an appeal. So you probably know what an appeal is. It means that, if you have a court decision, you can appeal it and it goes to a higher court who looks at the case and decides whether the judge made the right decision based on the facts and law. And most simply, that's what it is. So judicial review is pretty much a similar concept. I could technically kind of explain all the slight differences, but at the end of the day, it's basically like an appeal because for some types of decisions, there is no specific right to an appeal. It's just a right to a judicial review. Basically, Canada here is asking the Federal Court of Canada to look at the decision and decide whether basically the tribunal's decision was reasonable. And in order to file this judicial review, it had 30 days from the decision in September. So that's why we heard the decision to bring judicial review in October. But yeah, ultimately it's basically like an appeal. All right, so next. Let me explain now. Individuals who have been harmed by discrimination found under the Canadian Human Rights Act, according to that law, are entitled to individual compensation for their pain and suffering. So this comes from a couple of different parts of the Canadian Human Rights Act. One of them being Section 53(2)(e), which says that the tribunal can order compensation to the victim of discrimination for any pain and suffering that the victim experienced as a result of the discriminatory practice. So that's the jurisdiction of the tribunal to award compensation. Now, the Act actually sets a maximum amount that can be awarded by the tribunal, and it sets that cap at $20,000. Generally, the idea in law, just so you know, because we're going to talk about another head of compensation that the tribunal can award, but just to explain sort of some of the philosophy around pain and suffering awards in law, usually this type of compensation is not meant, really, its intent is not about punishing the wrongdoer, the party that discriminated, and that would be, here Canada, not this head of damage. It's really much more about trying to deter that type of wrongdoing, so preventing other types of discrimination in the future. And also, really, it's about trying to validate the victim's experience. So recognizing that that an individual was discriminated and harmed, and trying to use money, as the courts often do, to recognize that harm. Now, the tribunal says pretty clearly in the decision that it recognizes that $20,000 for an individual who has been apprehended or denied Jordan's principle isn't enough. And so here's a quote from the tribunal. And so, the panel stresses the fact that this amount can never be considered as proportional to the pain suffered, and accepting the amount for remedies is not an acknowledgement on your part, so you, the victim, that this is its value. No amount of compensation can ever recover what you have lost, the scars that are left on your souls, or the suffering that you have gone through as a result of racism, colonial practices, and discrimination. This is the truth. So the tribunal is saying, because what it ultimately orders is that every First Nations child who has been affected by the discrimination in this case is entitled to that maximum amount of $20,000 as recognition of their pain and suffering. But the tribunal also says very clearly here that it recognizes that it's not enough. But that's all that the tribunal can order under this head, $20,000 max. But it's saying we recognize it's not enough, but it is something. Up on that point and move to the other head of individual compensation that the tribunal can give under the Act. So under Section 53.3, the tribunal is able to order compensation to the victim if the discriminatory practice was engaged in willfully or recklessly. The maximum amount that the Act again says that the Commission can give under this particular head is again $20,000. And this actually is, unlike the other one, which is about trying to recognize the harm caused to the victim, and it's more focused on the victim and preventing further discrimination in the future. This particular section of the Act is really more about punishing really bad wrongdoing. So it's really meant, and it should only be used in cases where it's quite clear that the wrongdoer, the person that discriminated, knew or ought to have known about the harm that they were causing. And as you saw from my last video, there was a lot of evidence that the government in fact did know that it was causing this harm, and that they were underfunding services, and this was causing harm to First Nations children and family. And so even though usually tribunals only order this head of individual compensation only in cases where it's clear that there was reckless behavior, in addition to that, they only offer the full $20,000 really in exceptional circumstances in the worst case scenario. And here the tribunal says this was the worst case scenario. So we've got this quote: "This case of racial discrimination is one of the worst possible cases warranting the maximum award." And a little bit later in the decision, the tribunal goes on and says, "The panel finds that Canada's conduct was devoid of caution, with little to no regard to the consequences of its behavior towards First Nations children and their families, both in regard to the Child Welfare Program and Jordan's Principle. Canada was aware of the discrimination and of some of its serious consequences on the First Nations children and their families. Canada was made aware by the NPR in 2000. That's a report that was issued by Cindy Blackstock. I talk about it in the earlier video. And even more so in 2005 from its participation and knowledge of the Wende report. That's another one of the reports that Cindy wrote that was given to the Department of Indigenous Services to show the discrimination. And in fact, the government funded and participated in it. So tribunal says here that Canada knew about it. And it goes on, Canada did not take sufficient steps to remedy the discrimination until after the tribunal's orders. As the panel already found in previous rulings, Canada focused on financial considerations rather than on the best interests of First Nations children and respecting their human rights. So those are all reasons why the tribunal finds that this is one of the worst case scenarios of discrimination, and that it's a case where that remedy of an extra $20,000 for reckless and willful behavior is warranted. Okay, so let's continue. Let's look at what the different parties argued in this case around individual compensation, just so you have a bit of a better idea, and you'll have some understanding about what the government of Canada is going to try to argue in its judicial review. Okay, so as I mentioned in my first video, there's actually a few parties involved in this case. There's the Caring Society, and Cindy Blackstock is the executive director of the Caring Society. The Assembly of First Nations was also a party in this case, as was the Chiefs of Ontario, that's COO, and Anishinaabe Aski Nation, representing First Nations from Northern Ontario, were also involved in the case. They all made legal arguments dating back to 2014 in their submissions and their legal arguments to the tribunal, and they were all in favor of individual compensation as well as the systemic remedies in the case, right? So they wanted both of those, and it was quite clear. In addition to that, with respect to the compensation order, there was a bit of a difference in position between the Caring Society and the Assembly of First Nations. So the Caring Society proposed that the individual compensation owing to First Nations children should be put in a trust. So a trust is like a legal instrument where money that is owing to a person who for a variety of reasons might not be in a position to be able to manage it and spend it themselves, is put so that somebody who is supposed to act in their best interest manages the trust for them and ensures that the money is not spent on things that it shouldn't be spent on, and that it, and make sure the money is well managed. So the Caring Society proposed a trust for the individual compensation amounts, and that from the trust money would be taken from time to time to support programs and initiatives for First Nations youth and families. On the other hand, the Assembly of First Nations preferred that individuals would get individual compensation directly, and we'll come back to where the tribunal went with that. Okay, so those are what the First Nations parties argued. Then there was Canada. So Canada did, like everything else in this case, fought tooth and nail, against what was being argued by the First Nations parties. So when it came to individual compensation, Canada argued that this case was only about systemic remedies and was only ever about systemic remedies. There was no, at the beginning, the case was never framed as being about individual compensation for First Nations children and families, so it shouldn't be available. The parties shouldn't be able to ask for it now. It also made the argument that, there was no actual First Nations children or families that had been affected by the child welfare system that were actually involved in the case. Yeah, the Caring Society and the AFN said they were representing those people, but they weren't a part of the case. So Canada tried to argue it was because they weren't actually parties to the case, then the tribunal shouldn't be able to give them individual compensation. And also because Caring Society, AFN, and all the other parties who are part of the case are not individuals and are corporations or organizations, they shouldn't be entitled to an individual compensation. Also, they argued that there was no evidence in this case of harm to individual children and families to support individual compensation. And then finally they also said, hey, there's a class action that was started not too long ago, back in February. Just as an aside, that class action hasn't been certified yet, but there is a class action with respect to the children, First Nations children taken into child welfare care since the early 90s to now. So the Canada tried to argue, well, there's a class action. That's where compensation, individual compensation for children and families should be given. So it shouldn't be given in this case. It should be saved for the class action. So those were the arguments that Canada made. Then there was the Canadian Human Rights Commission. The Commission often will be involved in cases that are before the Tribunal, and what the Commission generally tries to do. Sometimes it may take a position that favors one side more than another, but what they try to do is kind of set out the law and their position of what the law ought to be based on the Canadian Human Rights Act and case law interpreting it. So here the Commission was involved, and the Commission supported the ability of the Tribunal based on their reading of the Act and case law interpreting the Act. They supported the Tribunal's ability to be able to give both individual compensation for pain and suffering, as well as the extra amount for willful and reckless behavior, as well as that the Tribunal had the ability here both to give individual and systemic compensation and remedies. Okay, those are the arguments. So basically, when it comes to Canada's arguments, once again, the Tribunal rejected what Canada was trying to argue. First of all, they agree with the Commission and the other parties that based on how the Canadian Human Rights Act is worded, the Commission or the Tribunal has the power to issue both systemic and individual remedies. And not only that, in this particular case, it was very clear from the outset that the parties of the Caring Society and the AFN were seeking both systemic and individual remedies. Because the Canada here tried to rely on this Supreme Court of Canada case where it was kind of the inverse or the opposite. Somebody was asking for individual remedies, which they got in a discrimination case, but then the Tribunal went further and issued systemic remedies too. And the Tribunal said, you went too far in that case, because in that case, the person who was harmed, the complainant, didn't ask for systemic remedies. So you went a little too far in doing that. But in this case, the Tribunal says it's different, because here it's very clear that Caring Society and the AFN were asking for both from the outset. And so Canada can't act like it's surprised by this request for individual compensation. It says Canada had ample notice of this, right? AFN and Caring Society made these arguments back in 2014. Okay, next, the Tribunal found that it can award compensation to victims of discrimination even if they are not directly a party to the case. Right? And we'll talk a little bit more about that after. But yeah, there's nothing in and the way the Act is worded, it does recognize that people can get compensation even if they're not directly involved. So long as they're, it was, the case was sort of set out and framed that they would still be entitled to discrimination. The Tribunal also found that just because there's a class action that is potentially going to be happening as well, that doesn't prevent the Tribunal from issuing individual compensation here. Lastly, to this argument by Canada that there was no evidence of harm to individual families and children by the discrimination carried out by Canada, the Tribunal just said, absolutely not. There was no shortage of evidence, both in the main decision and the 7 further non-compliance orders, of the harm that was caused by Canada to First Nations children and families through its discrimination and unnecessary apprehension of children, as well as its narrow approach to Jordan's principle. So here's a little snippet from what the Tribunal says in its opening paragraphs. The panel finds that the AGC, that means the Attorney General of Canada, that means Canada's position, the AGC's position on compensation unreasonable in light of the evidence, findings, and applicable law in this case. So very clear that the Tribunal disagrees with Canada's arguments. And, I've read the decision, and I think it's a very, very strong decision, and the analysis of the case law is on. So I think that Canada, this is just me talking, but I think it's going to be very hard for Canada to judicially review this. But anyway, that's what Canada has decided it's doing. The tribunal goes on in the later in the ruling to take this point further. It says the AGC, Canada's argument that there is no evidence of pain and suffering from children and families as a result of the discrimination is simply not true. This is a similar assertion that Canada has made on the evidence to prove the complaint on its merits. So Canada made the similar argument that there was no evidence of discrimination. In fact, such a conclusion by Canada is concerning to say the least, right? Because they didn't appeal the decision, and they accepted that there was harm. But anyway, so the tribunal goes on. It also raises questions from this panel. The harm done to First Nations children who are vulnerable and to families and communities is precisely why the panel issued numerous rulings requesting immediate action. This panel recognizes, as described by the Caring Society, the rights of children are human rights that recognize childhood as an important period of development with special circumstances. This is also recognized by all levels of courts in Canada and was discussed in this panel's decision on the merits. So here again, and the tribunal is actually really seriously questioning how Canada can in good faith make the argument that there's no evidence of harm to children. Given what, the fact that it didn't appeal the earlier decision, given all the other non-compliance orders against it, it's very clear that they've been causing harm. So the tribunal really finds it concerning that Canada takes this position and is continuing in the judicial review that it's taking forward to make this argument. In fact, although in the media the federal government has been saying that it just wants a fair look at this ruling, if you go read the court documents, Canada's saying that there should be no compensation for this harm at all. Okay, so I've walked you now through sort of the main findings of the tribunal on this compensation decision. So what does it mean? What's the actual nuts and bolts of the decision for individuals who, children and families who have been harmed by the discrimination by Canada? So there's two different basically heads of compensation. I'm going to cover them both on different slides. The first one is compensation for unnecessary apprehensions or placements. Okay, so there's basically four subcategories of this. I'm going to try to explain. But first of all, I'll make the point again, as I said at the beginning, this particular heading doesn't apply to the Northwest Territories or Nunavut. Really, it's applying to child welfare services on reserve and in the Yukon because those were funded under the First Nations Child and Family Services Program. Okay, another point I want to make before I go through this list of four is that you're going to see in every one that there's a date given of January 1st, 2006. All of the compensation is for after January 1st, 2006. So what's important with that date? That date relates to the last report that Cindy Blackstock with the Government of Canada made around the discrimination to First Nations children and families under the Child Welfare Program. And she thought that the government would do something about it, but it didn't, and that's why she had to finally bring this complaint. So the January 1st, 2006 time deadline or date is to say, okay, that's when Canada knew without a doubt that it was discriminating against First Nations children. So that's why the date starts there for the tribunal. I'll make a quick note, the ongoing class action that's being filed, that goes back to 1991. It also alleges there that Canada would have had knowledge at that point too, and that may well be the case. It's not saying that date between 1990 and 2006 also isn't relevant, but for the purposes of the tribunal and its order, it's using that January 1st, 2006 date. Okay, so there are four heads or four ways that you can be entitled to compensation for unnecessary apprehensions or placements. Okay, so basically, the amount here for all of these is $40,000. So that's the $20,000 for pain and suffering under one part, the part that we already reviewed, and then with respect to pain and suffering, and then the other section that's about willful and reckless treatment. So the other $20,000. So that equals $40,000. So the first one, someone will be entitled to, a First Nation child will be entitled to $40,000 if they were taken into care where the removal could have been prevented. And basically that means if there would have been, if Canada had adequately funded the service, adequately funded the program, and had provided adequate prevention services, then that would have been avoided. But the system wasn't structured that way. So one thing to point out here is that generally this is going to be related to cases where a child was taken into care because of something like neglect, right? Because of that might be because of poverty issues or substance abuse issues, but a child was removed not because of abuse. I'll come back to abuse, but generally these are going to be in cases where children were removed from their families because of issues relating to neglect and poverty. Okay? Number 2, $40,000 for each child removed from their families, and for, again, similar reason to number 1, would have been for neglect, and then returned, at some point returned to their immediate or extended family. So number 1 assumes that they never returned to their family. 2 assumes that they did eventually return to their family, so they were only in care for a temporary period, but nonetheless they are going to be compensated for that period of time that they were separated from their family. So they're equally entitled to $40,000 as well. Okay. All right. Number 3 is specifically for the experience of children who may have been abused, and so in this case they were not unnecessarily removed. There was good reason perhaps for them to be removed because they were subject to physical, mental, or sexual abuse. Psychological abuse. So physical, psychological, or sexual abuse. So there was reason for them to be removed, but even still, the tribunal says that it may have been, it was still discriminatory because the program was funded in such a way that they were, if they were placed outside of their extended families and communities, they're going to be entitled to $40,000 as well. Right. So, yeah, there's recognition here that if there was a situation of abuse, then the apprehension of the child would have been necessary, but oftentimes children may have been apprehended but not put in kinship placements or placed with a family member because of the way the system was structured, but instead placed with a non-Indigenous family or something like that. So the tribunal really feels that children should have been placed with people that they felt safe with and that they knew and that were family members. So category 3 also entitled to $40,000. Finally, there's category 4, which is not for children, but for actually the parents or grandparents of children falling into category 1 or 2 who were unnecessarily apprehended, either permanently or temporarily. So if a child was apprehended and a parent or a grandparent was providing primary care for the child, was taking care of that child, then they are entitled to $40,000 as recognition of the pain and suffering that they experienced from that discrimination. Okay, so a point to make here, and the tribunal points this out too. Parents and grandparents who were abusers are not going to be entitled to this. So that's why number 4 really relates to parents or grandparents whose children fall under category 1 and 2 here. Number 3, for those that fall under number 3, the tribunal holds that even though, sometimes the abusers in our communities are themselves people who are subject to abuse because of things like residential schools and other things, nonetheless, they recognize that it's important for children who were abused to feel vindicated and not to have to see their abuser receive financial compensation. So parents or grandparents who may have abused children and that was the reason that they were taken into care will not be entitled to compensation here. Okay, a couple other points about category number 4. It's limited to parents and grandparents. So if you're a sibling who took care of a child, or an auntie or an uncle, the tribunal says they don't want to diminish the pain that they may have experienced if the child was taken out of their care. But ultimately they feel that they have to make some sort of reasonable cutoff, and they just can't go that far back into the family. So it's limited to parents and grandparents. Okay, so yeah, those are the 4 categories with respect to unnecessary apprehensions or placements. Okay, the other category of individual compensation that First Nations children and families are entitled to is for delay or denial of Jordan's Principle. Okay, so the first thing to note here is that the tribunal said that Jordan's Principle applies across the country, that it has to be given a broad definition, and so unlike the other head I just described, this one applies also to First Nations children and families in the Northwest Territories too, and it applies on and off reserve. Okay, so entitlement number 5 gives $40,000 to each child who, as a result of a gap, delay, and or denial of services, was deprived of essential services and placed in care outside of their home, family, and community in order to receive those services from December 12, 2007 to November 2, 2017. So it's a child who was denied a service because of jurisdictional fighting, and then placed, because of that, placed in care in order to receive that service. All right, and there's a date given here, and if you're curious about the date is December 12th, 2007. That's the date that the Government of Canada passed the resolution in favor of Jordan's Principle. So that's when Canada said it would respect Jordan's Principle. And November 2, 2017 is the date when the tribunal clearly said that Jordan's Principle requires Canada to clearly comply and provide a broad definition of Jordan's Principle. So if a child was deprived of services within that time period and were placed in foster care because of that in order to access a service, then they're entitled to $40,000. Number 6 is for a similar reason, but it's now compensation for a parent or grandparent who was taking care of a child who was denied a service, and as a result of that denial was removed from the home and placed in foster care in order to receive that service. So a denial of Jordan's Principle, and it's again between those dates. So this one is to recognize parents or grandparents who would have been affected. Okay, the next one is $40,000 to each child who was not removed from their family home and but was either denied services covered under Jordan's Principle as defined in the tribunal's decisions. There's 2 there, 14 or 35, and that could have been services like mental health, suicide prevention services, special education, dental services. or who receive such services after an unreasonable delay or compensation or upon reconsideration ordered by the tribunal. So number 7, basically it's giving compensation to children who were denied Jordan's principle. And it doesn't matter if they weren't removed from their home. And here I think it is in particularly related to once the tribunal made its order in 2017 and defined Jordan's principle. If Canada can continue to disregard that, as we know from the further compliance orders, anyway, a child is entitled to compensation based on that denial. And 8 is related. It's compensation to a parent or grandparent of that child who, although not removed from their home, was denied services under Jordan's principle. Okay. One thing that the tribunal says in its decision is if a family or a child receives compensation for removal under the earlier head of compensation, so number 1 to 4 that we looked at, you can't necessarily combine that with a Jordan's principle compensation that recognizes that you've been removed from the home. So basically you can't recover twice for having been taken out of the home for essentially the same reason, although one of them also involved denial of Jordan's principle. Again, here too, the compensation to parents and grandparents are parents and grandparents of children who were apprehended or denied Jordan's principle in situations that don't involve abuse. The tribunal, as explained earlier, does not want to give compensation to individuals who would have committed abuse. Okay. All right. Final few slides on the ruling on the compensation process. So there's lots of things. It's a big decision. It will apply to a lot of people. And there's lots of things that need to be worked out. And I understand that, Cindy and the Caring Society are really hoping to hear your feedback and learn about, what you think of how the process should look. So yeah, there's things that definitely need to be figured out. So let me just walk through some of the things the tribunal said on this. So first of all, to that, different approach between the Caring Society, who wanted to see the compensation funds put in a trust for all First Nations children that would then be used to support First Nations programs and services, versus the AFN, who said it should be for individual compensation. The tribunal orders that that children and families who have been affected by the discrimination should be entitled to individual compensation. Now, the tribunal is not against the idea of a trust, and says a trust for, to use for services would be a good thing, but it should be in addition to individual compensation to people for the discrimination, and not a replacement of it. The tribunal also recognizes and agrees with the Caring Society on the argument that there's going to have to be a trust, though, for children who are under the age of majority. So it depends on the province, but it could be anywhere under, between 18 to 21. And so it's going to have to be figured out between the parties, if this compensation process goes ahead, what to do with money for young children. So who should hold the trust? Those are the kind of issues that are going to have to be worked through. Could it be administered or managed by children and grandparents of who take care of children? So there's some issues that need to be worked through there. Other issues that are going to have to be worked through is, in terms of providing compensation, we're going to have to be sensitive to issues of consent and eligibility and privacy. So those are all sort of ongoing issues that need to be worked out. Another thing the tribunal held on the compensation process, and this is sort of to arguments that Canada was making, that it's not necessary for the tribunal to have to hear from every child who was taken into care or denied Jordan's principle, to have to hear their evidence about what that did to them, what the harm that discrimination did to them, in order for them to be able to be compensated. Already mentioned that the tribunal finds that there is ample evidence in the case and in the non-compliance orders of evidence of this harm. Also, the tribunal says it doesn't want to do this because it risks possibly re-victimizing children and families of having to open up about their experiences if they're required to give direct testimony. So the tribunal doesn't want to do that. What the tribunal says that the parties should discuss and negotiate moving forward in this process is having some type of simplified process similar to that existed with the Indian residential schools common experience payment. There, what you needed to show was proof that you attended a particular institution and the number of years that you attended, and that was sufficient to claim compensation. So in that regard, the tribunal says, we've got things that can help us to prove that those specific things. Like we have the Indian Status Registry and also records from the Jordan's Principle process that will show us who's been denied and who's been taken into care and that are our First Nations children. So there's records that can help, and so that was a suggestion of the tribunal on how to move that process forward. One last thing too on this slide is that with respect to the compensation that the tribunal orders individuals to be entitled to, it also orders that there can be interest on that compensation using the current Bank of Canada rate for interest. Okay, second to last slide here. Obviously from the last slide you can see there's lots of things that have to be negotiated and with respect to rolling out a compensation process, and the tribunal has maintained jurisdiction to be able to help the parties come to decisions on this. Ultimately the tribunal wants to see the parties agree, including Canada and the AFN and Caring Society, on how the process is going to look. That's all going to be a little bit up in the air now while the judicial review is happening, but that's what the tribunal wants to see. But the tribunal is going to stay in the picture if the parties can agree to ask for support and assistance, and in some cases make a ruling. So some of the compensation, some of the issues that are really going to have to be touched on and really figured out that we don't have answers to right now are this question of eligibility and proof. I talked about some of this on the last slide. How to ensure a process that's going to protect individuals' privacy and make sure that they, provide the consents that they need to in order to use their information. There's also going to be an issue too that often arises where there's compensation, whether it be under 60 Scoop or Indian residential schools, but for people who are receiving social assistance benefits, making sure that those amounts paid under compensation claims don't get clawed back, or having your benefits cut off just because you're getting compensated for discrimination that you experienced. Another thing that the tribunal said in the case was that, there's some people who've been affected by this whole system who may not want compensation, or who may not agree with the AFN representing them in this process, or stuff like that. So the tribunal says there has to be an opt-out process. So if somebody doesn't want to receive compensation, there needs to be a clear opt-out process for them. Finally, there's one issue, and it's come before the tribunal already, around who is a First Nations child. So there is a decision from 2018 from the tribunal where there was a bit of a disagreement again between Caring Society and the AFN with respect to who is a First Nations child. And the tribunal gave a ruling on it, but it was only for very specific cases where there was an immediate need of a child for Jordan's Principle service. So the issue was because of the Indian status rules, and those themselves are discriminatory and continue to, now with children who are born to one parent who is a status Indian and a parent who is not a status Indian, now, after 1985, you lose, for every generation there's that mixing, children will lose status. So after 2 generations, basically it means that after 1985 you have to be half, and if you're less than half First Nation, then you don't have status anymore, and that's a problem. I could do a whole other video on that, but nonetheless, there are communities that have membership codes that do recognize that even if children don't have status, they're still a community member. And, even beyond that, there's communities who still see children who are, children of members from their community, even if they don't technically have status, they still consider them to be members. So the case was around that, whether children who don't have Indian status, whether they're First Nations children, and the case that the tribunal heard was really specifically about First Nations children living off reserve and whether they should be entitled to Jordan's principle even if they don't have First Nation status but are otherwise recognized by their nation. Anyway, so the tribunal gave a temporary sort of order with respect to very specific cases of need with respect to Jordan's principle, but there's this bigger issue out there, right, that it has to be decided between the parties around who is a First Nations child. So that's a big one. Anyway, all stuff that I'm sure the Caring Society would love to hear, youth who've been involved in this system, your take on these issues. Okay. All right, so finally, I guess there were some questions that you had submitted to Cindy or to on an online forum about some of the questions they got. And so a couple of questions you guys posed is, what kind of work is being done across the country around child welfare reform? So on this point, in terms of long-term reform, there is currently research underway by the Fiscal Studies and Development Department at the University of Ottawa that is looking at creating a funding approach that enables First Nations children, youth, and families to thrive. So there's a project underway. You might get a presentation on that. And what they're hoping to do with this model is to, address drivers of overrepresentation in the child welfare system, such as housing, poverty, substance abuse, and addictions. So you may be being provided a presentation on this, and there's a website that you can check out on this research that you're going to be provided. Also, many agencies, First Nations agencies, are already working with communities on trying to do some long-term planning, including development of laws around the reform of child welfare. You may have heard that there was a bill passed in Parliament in the summer by the Liberals called it's about Indigenous Child Welfare Services, First Nations, Métis, Inuit Child Welfare Services. One of the things it does is give communities the ability to pass their own child welfare laws that can overtake provincial laws on child welfare. And so there's that bill that is out there. One of the key challenges from that bill is that currently, kind of sounds like same old, there is no implementation plan that has been developed by the federal government, and there also has been no obvious source of funding identified to help communities, first of all, develop these laws, and even more importantly, to operate these services under their own laws. So again, we're running into a challenge around funding of services. So that's a big issue. And so it would be great if YCC, you guys would consider sending the Prime Minister a letter noting your views about this if you feel that that's wrong. And, there's a real urgency around this because that law that I just referenced it's going to take effect on January 1st, 2020. And so right now there's no regulations, there's no transition plan, and there's no money to support communities to develop these laws or even provide these laws in their communities. So that's a huge issue. So if there's some work that you want to do to help us push the government to make changes there, and to really support this work, if you can take action on that, that would be great. Okay, second question. How can I be more involved in policy and legislative work around child welfare reform? So, you providing input into long-term reform at this particular forum is very helpful. Also, if you want to explore a conversation with the team that is working on that new funding formula, the Fiscal Studies and Development Department, that would be really helpful. Cindy would be happy to help facilitate that. And there's also work that you can do in pushing governments, especially the federal government, to implement the Spirit Bear Plan. I think you're going to get copies of the Spirit Bear Plan. It's also available on the Caring Society website. But it's something that Cindy and those who have been working with her on this case recognize as really important work that needs to be done. A part of it involves a sort of 360 review of the services that the federal government provides to First Nations, and identifying gaps and how to fix those gaps. And so anyway, you'll take a look at the Spirit Bear Plan, but it is critical to ending the inequalities that First Nations children and families continue to face, that also continues to contribute to the overrepresentation in the child welfare system and many other disadvantages that our communities continue to face. So if you can do work to help promote and get government to commit to implementing Spirit Bear Plan, that's another great thing that you can do. That's the end of my presentation. Thank you very much for watching. I hope that it was helpful. Enjoy the rest of your time together, and I will be I believe calling in by Skype and answering some questions for you later on today. Thank you.